we getting sometimes is a violation of criminal. Criminal is the simple one is the for example assault and battery, something like that, and then severe one, but the lot of person is a violation for driving under the influence or DUD. DUI is the driving under the influence. DUD is driving while intoxicated or impaired. TWD. If you are driving a car and you are suspected of driving under the influence, alcohol or drugs, you should keep in mind at the following. When you violate the under the influence, first one is blood alcoholic test. Blood alcoholic test, concentration test, blood alcoholic concentration tests, we say. Concentration test, driver will be concentration test by choosing between a breath test or a urine test and a blood test. If you refuse the test at this time, you will be considered drunk drive and you will be convicted. If your blood alcohol content is 0.08 or higher, you will be arrested on the spot and taken to the police station. 0.08. 0.08 normally one bottle of the beer, one glass of the wine, something like that, in drink within 30 minutes. You're moving 0.08. When you drink at the meeting, at least drink after 2 hours, you should move it. And then, even at the ground test, 0.08 under. They usually sleep overnight and are released the next day. If you have been involved in a car accident, when you go to the police office, they usually sleep overnight and are released at the next day, pay bond and the court date. If you have been involved in a car accident, in case you will be brought to the trial with a lawyer you have chosen or with a public defendant if we are found guilty. Generally, if you don't have any money, you can hire the attorney. Any criminal cases, you can request public defendant. Public defendant is free. Somebody can help you. Normally, if you go to a court, the fine is generally $1,560 with various promotion money. Added to the total fine is around $3,000. Attorney fee must be prepared separately around $5,000. If you don't have any money, you can be requested public defender. But if you find any DMV, not DMV, DUD, driving under the influence, at least you should spend the money $10,000 to $20,000, and then for insurance fee so high rate, and then to one recording, criminal recording you got it. First time drunk driving education will be imposed according to the level of alcohol in the blood. At the court, first offense 96 hours to 6 months for jail. 6 months driver's license suspended. You must enroll in a drinking education program for 6 months. Too terrible. Do not for drinking drive. If you according to the court drinking drive, after finishing the sentence and then paying all the penalty payment, you should do expunge. Expunge meaning release your recording. If not recording, forever the recording is on the court. You cannot hire any places. When you're finishing the public sentence, you request for the expungement. Expungement is so important. When you live and commit a crime, a record remains. If this record remains, you will not be able to apply for permanent resident. You cannot permanent resident. Green card, you cannot apply green card or citizenship, and you will not be able to get a job. For example, in Korea, the criminal record cannot be permanently erased, but in the United States, the record can be erased, and this is called expunged. A few things you need to know before applying for criminal record erasure expungement. If this is detected once, when passing through the airport, somebody, whenever passing through the airport, he go to the inspection so long time. That one is also one time when you come to the United States, one time you inspect. Every time you get getting for the inspect. In case also, every time wasting a lot of time, in case when the passing through the airport, to the airport request for the expungement. Well, called airport expungement is the simple. You send the letter. I got some recording, so and so, but after that, I didn't do anything. Please, my name is released for the expansion, and then so easy. But the criminal recording is to the court, superior court, criminal superior court. We should request for the expungement. Procedure and method of expungement of criminal record. First thing, you go to the criminal court for the superior court. When you go to the court, first of all, you should stop by police office when you rest. Even a few years ago, when you rest in the any police station in Koreatown, you should go to Koreatown police office just a driver's license. I need a criminal record for the expungement. And then they say right away to the computer, you put right down your driver's license, and then they issue right away criminal record, date of arrest, reason for prosecution, DUI, and indictment or case number, words number, the date of sentence, the content of sentencing. This kind of information you request for the criminal record in the police office, police station when you arrest, they give you. You can request for this recording for police station of arrest. And next time, at the end of the trial, you will receive a judgment from the court. Expunges is simple, just a 2 pages for application. Put route. Oh, that's this page. Expunge criminal record step by step. Disclaimer. This packet is intended as general information, only guide you are filing your own expungement. Your situation may have factors requiring different procedure or funds. If you need further assistance, you may want to hire a private attorney. Anyway, you should hire your private attorney. This expungement, they don't have any help for the public attendant. You should do the attorney or paralegal or any other person can help you. You have obeyed the law and lived an honest and upright life since the time of your conviction. You are eligible for a dismissal, and the court has the different choice to grant you the dismissal if you received the probation but you did not get an early release. For example, probation 5 years, you receive it, and then you can request for the expungement after 5 years. Finish for the probation period. Or convicted of any other offense listed in Vehicle Code 128102. But first, you have paid all the fine restitution, and reimbursement ordered by the court as part of your sentence, and you are not currently charged with on probation for or serving a sentence or any other offense. Some convictors are not eligible for dismissal. If you are convicted of any of the following offense, you are not eligible for dismissal under Penal Code Section 1203, and dismissal within the provision of Vehicle Code Action, any violation of Penal Code Section, a felony under Penal Code Section, any infraction. Some cases cannot eligible for dismissal, not the expungement forever. First one is forever you cannot request for expunge. First one is regarding sexual recording, any kind of sexual, any kind. That's in the United States. Sexual recording is too terrible. Expunge criminal record step by step. Even the sexual food, sometimes your friend is come to your house and then he say I'm not allowed for the Hollywood. You ride on your car and go to the Hollywood. But sometimes on the street, one lady, black stocking, and then to short pants, something like that, and then on the street. Your friend is down the door and just to say, hey, how much? Just as he say, how much? And then right away, she on the her head, backside is the taxi will come through, and then police, he say, you are sexual violation, and then give the ticket. After 1 month, go to the court. Just to say how much, that's all. Not go to the motel, hotel, or any other touch, no touch her body, but say how much. This is a sexual violence. This recording, forever, you cannot expunge. Too terrible. Sometimes his pastor, his friend from Korea, pastor driving on the street, his friend is down the window, and then to say, how much? Somebody say, ¿cuánto? 얼마예요? All of them, that's sexual violation. Not just to him. 4 persons on the car, driving pastor, all of them they are recording. Forever, they cannot expunge. Too terrible. Be careful. Okay. Disclaimer. This packet is intended general information only to guide you in filing your own expungement. Your situation may have factors requiring different procedure or forms. If you need further assistance, you may want to hire private attorney. Background check. You should disclose a conviction and expungement in these situations if you are applying for a government issued license, certificate, permit. You must disclose your conviction and expungement. How does an expungement affect strike or other sanction? What's the problem? Computer. Although your conviction may be dismissed, the sanction such as firearms prohibition, exclusion from jury duty, or strike cannot be dismissed. These remain in fact for life. An expungement does not remove the conviction from a criminal history. California and FBI criminal history code will still show the conviction and the subsequent dismissal. Also, retain your right to possess firearms. Also, allow you to omit the conviction from application for government or issue license. Next, see the court case file from public inspection. The court file remains public record. Prevents the conviction from being used as a prior for sentencing enhancement is subsequent conviction. Prevents the conviction from being used by U.S. citizenship and naturalization service for removal or exclusion purpose. Are you eligible for a dismissal? You are eligible for dismissal for a conviction, and the court will dismiss your conviction if you receive the probation for a conviction and, number one, you successfully complete probation or obtain early release. Two, you also have paid all the fine, restitution, and the reimbursement ordered by the court as part of your sentence. Three, you are not currently serving another sentence or on probation for another offense. And four, you are not currently charged with another offense. You never received the probation, and number one, your conviction was dismissed. Misdemeanor. Number two, it has been in at least 1 year since the date of you were convicted. Number three, you have complied fully with the sentence of the court. Number four, you are not currently serving another sentence. Number five, you are not currently charged with another offense. And yeah, paper is even the defendant's court document. Court document is a CR 180. Even you can get in the paper from the criminal civil court. You can this document you can. Attorney or party without attorney bar number. This is bar number meaning for the attorney bar number. Name so and so. If you don't have any attorney, that's your name. You party without attorney. Name so. Form name you don't have any. Street address, your house, city, state, zip code, telephone number, fax number, email address, attorney for defendant, your name. People of the state of California, meaning not person in California, people meaning district attorney. District attorney is people. Defendant, your name, date of birth, and petition for dismissal. Court use. This one you cannot put right down. On day to day, the petitioner meaning defendant in the above entitled criminal action was convicted of a violation of the following offense or was granted deferred entry of judgment for the following offense. This section you receiving for the criminal record from the police station, that's code number, section, type of offense, felony, misdemeanor, or infraction, normally misdemeanor. Eligible for reduction to misdemeanor under penal code, so and so. You can read for the criminal code. Eligible for deduction to infraction under penal code. Eligible meaning I finished for my sentence and I paid all the penalty. That's it. Number 2, felony or misdemeanor with probation granted. Felony or misdemeanor. Probation was granted on the terms, the conditions stated in the docket of the above entitled court. The petition is not serving sentence for on defense, not on probation for any offense, nor on the change of the commission of any crime, and the petitioner. Number 8, has fulfilled the condition of probation for an entitled printed period. All condition of probation of the entire period in their mark, or has been discharged from their probation prior to the termination of the period thereof, should be granted relief in the interest of justice. Something like that. Normally, number 8. Number 3, misdemeanor or infraction was sentenced other than probation. Probation was not granted. Probation meaning for the when you go to the jail. Probation not granted. Probation is the not go to the jail. Just a period. Probation was not granted. More than 1 year has elapsed since the date of pronouncement of judgment. Petitioner has implied with the sentence of the court and not serving a sentence for any offense or on the charge of commission of any crime, and the petitioner, number 8, has lived an honest and upright life since pronouncement of judgment and conformed to obey the law of the land. Of mark number 8 normally. B, should be granted relief in the interest of justice. You must explain why granting dismissal would be an interest of justice. You may complete the attached declaration. There's so and so reason for some, but the normally number 8 is simple. Next, misdemeanor conviction under penal code section. Petitioner has a complete a term of probation for a conviction under penal code section. Normally, number B, petitioner should be granted relief because the petitioner can establish by clear and convincing evidence that the conviction was the result of his or her state of victim of human trafficking. Number 5, felony count jail sentence, felony count jail sentence under penal code something. Petitioner is not under supervision under penal code section 1170 5B and not served no sentence, foreign probation for, or charged with the commission of any offense and should be granted relief in the interest of justice. Number 8, more than 1 year has elapsed since petition complete. The felony county jail sentence with a period of mandatory supervision imposed under penal code something. B, more than 2 years have elapsed since petition complete. The felony county jail between a sentence without the period of mandatory supervision imposed under penal code section. 1 year or over 2 years, something. Number 6, deferred entry of judgment. Petitioner performed satisfactorily during the period in which deferred entry of judgment was granted. The criminal charge were dismissed under penal code section. A, court record unavailable showing the case resolution. B, petitioner declared under penal code perjury that the charge were dismissed after he or she complete the requirement for deferred entry of judgment. Petitioner has or has not attach a copy of his stated summary criminal history information at the courts. Number 7, petitioner requested that the eligible felony offense listed above be reduced to misdemeanor. under Penal Code section 17B, an eligible misdemeanor offense be reduced to infraction under Penal Code. Some attorney, somebody say, just expunge is misdemeanor only, not felony. That's wrong. Even the felony, they can request for the expunge it. But the misdemeanor is one time, but the felony is just 2 times. First time, I get in the felony, but reduced misdemeanor. First one is a felony reduced for the misdemeanor. After that, they receiving the proof from the court. After that, right away, I request for my misdemeanor is expungement. Sure to remember, for the also felony also can do it. Number 7, this one, petitioner requests that the eligible felony offense listed above be reduced to misdemeanor. This one, first one. This is first. And eligible misdemeanor offense be reduced to information under Penal Code section, something. Even misdemeanor pleading for just 1 year less sentence, over the 1 year, all of them the felony. That's a felony record is also you request for expungement. Petitioner requests that he or she be permitted to withdraw the plea of guilty or non contender, that the burden of finding of guilty be set aside and the plea of not guilty be entered the court to dismiss this action under something like that. For remember, for even that any recording, finishing the recording, you can request for expungement, but drinking drive is first offense, first one is after 5 years, you can request for expungement. Second time, you request for after 7 years. Drinking drive is a little bit higher, difficult. First offense, after 5 years, you can request for this misdemeanor. Even court is the sentence 1 year, but after 5 years, you request for the expungement. Even before the 5 years, you cannot request for permanent resident or naturalization for the any document. You cannot petition for your family. Be careful, do not for DOI. I declare the penalty of perjury under the law of the state of California in that the foregoing is true and sentence, date, and your name and signature. This is the petition for dismissal. Same time, first thing is this paper, petition for dismissal. After that same time, you should apply for order for dismissal. First one is petition. Second one is order for dismissal. That's the paper you kept. On the title scale, same thing, your name, street address, city, something like that, defendant name, everything is same. Petition for dismissal. But this time is order for dismissal. Number one, the court granting the petition for reduction of a felony felony to number one, again, the court grant meaning permit the petition for reduction of a felony to misdemeanor, reduction of felony to misdemeanor, maximum punishment of 364 days per penal code, on the penal code or something, and for reduction of a misdemeanor for an infraction on the penal code or something. All felony conviction in the above entitled action, all misdemeanor conviction in the above entitled action, only the following conviction in the above entitled action. Second one is all misdemeanor conviction in the above entitled action. Mark. If you are requested for the felony, first one, this all misdemeanor conviction in the above action, after you receiving this document, after that, your petition of dismissal one more time, and then next time, first one, all felony conviction in the above entitled action. Number two, the court to deny a petition for reduction of a felony to misdemeanor. This one is deny, reject. Misdemeanor to an infraction on the penal code section something. All felony conviction in the above entitled action. Felony conviction, no, not granted. All misdemeanor conviction in the above entitled, no. In case you request for sexual harassment or on the street just to your friend, it's how much? And to the court, you request for sentence 1 year probation. Even 1 year probation, you cannot release. If you request it, number two, all misdemeanor conviction in the above entitled deny. You cannot. Three, the court grant the petition of dismissal regarding the following sentence. And in this order that the plea of guilty or not a contenders or a convict, the finding of guilty, set aside and vacate, and plea of not guilty be entered something. It's granted. All conviction or plea for deferred entry of judgment. Normally, this one is marked. Number four, the court to deny the petition for dismissal on the court, something like that. Second, all conviction above entitled action. Just you request for the petition with this paper number 1, the court granted all misdemeanor conviction. That's all. The underline is the just blanket. Next page, 5. In granting this order on the conviction penal code section, find the sender a petitioner as a victim of human trafficking when he or she committed the crime. The court order the relief described in the section, not this section, just a blanket. Number 6, if this order is granted under the provision of Penal Code section 1203. Number 8, the petition is required to disclose the above conviction is response to any direct question contained in any questionnaire, its application for public office or full licensure by any state or local agency, something like that. Dismiss the conviction does not automatically release the petition from the required. Everything is granted. Number 7, if the order is granted under the provision of Penal Code section 120349, Department of Justice is hereby notified that petitioner was a victim of human trafficking when he or she commit the crime and the relief order. Number 8, if the order is granted under the provision of either Penal Code section 1203, petitioner is released from all penalties and disability resulting from the offense except as provided in Penal Code section, something like that. Next, number 9. In addition, as required, Penal Code under the Code section something does not release the petitioner from the separate administrative duty to provide specimen samples, print impression on the DNA, something like that. Number 10, the base for an order to dismiss are granted under the provision of Penal Code section 12343 in the invalidity of the defendant due to dismission misinformation in Penal Code section 1000.4 requiring the actual consequence is making plea and successful completion of a deferred entry of judgment program, justice, judicial offense, something like that. Whenever you request for the expungee, if not request for expungee even past 10 years, 20 years, recording is there, you cannot go to the immigration office. You cannot go to the any working. If we're gonna do that any other criminal law violation, you should remember the criminal violation. If not, anyway that in the United States, no more that the criminal violation. If we can do that the criminal violation, we do. We can after finishing the sentence, request for the expunge. Should remember. Intentional tort. First one is a tort. A person intends to perform an action that caused harm to another. If defendant intentionally frighten a person with a bad heart, who then has a heart attack as a result of the action, it would be an intentional tort even though defendant did not have the intention of causing the heart attack. The type of assault vary. First, imprisonment, intentional infliction of emotional distress, trespass to land, trespass to chattel, and convulsion. This one is the basic criminal law assault, battery. Normally, any other country is just battery, but United States is assault and battery. Assault and battery meaning if somebody fights each other, hand is touch my body in battery. Touch before the touch, just to show up. This is assault. And if somebody shoot the hit and assault and battery, forced imprisonment, protect for the passing, intentional infliction of emotional distress, trespass to land, other person's house or any property, trespass to chattel, and conversion. Assault meaning for the intentional placing to another in reasonable apprehension of an imminent harmful or offensive touching without consent or privilege. If a defendant intends to make a plaintiff apprehensive by appearing to menace her with a loaded gun from 50 feet away, an assault has been committed even if the gun is in fact unloaded. Just enhance how with the load gun from 50 feet away, the assault not touching, still assault. Assault has been committed even if the gun is in the fact unloaded. Load or unloaded, doesn't matter, just the gun is pointed somebody, this is alert. Also battery, the intentional harmful or offensive touching of another without consent or privilege. Defendant threw a piece of wood at plaintiff intending to injure her. The wood misses the mark but strike a pile of rocks, setting loose an avalanche of rocks that kills plaintiff. Defendant acted directly or indirectly brought about the injury that led to the plaintiff's death of setting loose of the rocks. This battery. 4. Transfer the intent to doctrine. Defendant's wrongful intent to transfer from the intended victim to actual victim or from the intended tort to the commit tort. Defendant sees Smith and acts on defendant's share. Defendant throws a stick at Smith or X and accidentally hit plaintiff. Defendant is liable to plaintiff, even though it was not plaintiff he was trying to hit. And forced imprisonment. The intentional physical or psychological confinement of another within fixed boundaries for any period of time without consent or privilege. A football player may be confined by frail run who grabbed the player's coat intending to detain him. Forced imprisonment. Intentional infliction of emotional or mental distress. Conduct of an extreme and outrageous nature, which is calculated to cause and which does cause severe emotional distress. Threatening language by bill collectors. Billing tactics of landlord seeking their rent. Insult heard in public and deliberate killing plaintiff get dark are typically caused of extreme and outrageous conduct. And trespass to land. Trespass to land meaning the intentional entry upon the land or possession of another without consent or privilege. Defendant, an absentee owner, visit his property, which is a farm. He drives a tractor on what he thinks is a parcel, but unbeknownst to him, he drives over what is really plaintiff's land. This is trespass. Despite defendant reasonable ignorance of the fact that the land is entirely belong to someone other than defendant. Trespass to chattel. Intentional interference with the chattel in the possession of another without consent or privilege. Defendant picks up plaintiff's book in the library, thinking it is her own. She underlines a few pages, then discovers the error. He returns the book, although defendant's mistake was completely innocent. She nonetheless intended. The physical act of picking up the book and marking it, and she is liable for trespass to chattel. One more time as I make an explanation regarding the trespass to chattel. Intentional interference with a chattel in possession of another without consent or privilege. Defendant picks up plaintiff's book in the library, thinking it is her own. She underlined a few pages, then discovered the error. The return the books, although defendant's mistake was completely innocent. She nonetheless intended the physical act of picking up the book and marking it, and she is liable for trespass to chattel. Conversion. Intentional exercise of wrongful dominion and control over the child of another without consent or privilege. A towing company is liable for conversion when he refused to deliver an impound car until outstanding charges are paid, even though it mistakenly believes it has a lien on the car for such charges. And nuisance, unreasonable interference with the right command to the general public. One must suffer injury different, a kind apart from that suffered by the general public in order to sue. An obstruction on a public road is a public nuisance, but it is a private nuisance as to plaintiff if it also blocks her driveway. Nuisance meaning for the public nuisance or private nuisance. Next. Consent must be voluntary, manifested by word or action of silence in the case where a reasonable person would speak if it was objectionable, not induced by fraud. Expressed consent is when plaintiff actually communicate to a defendant's willingness to submit to defendant's conduct. Implied consent in a when plaintiff by conduct has leave defendant reasonable by belief that plaintiff is willing to submit to defendant's act. Plaintiff's failure to object to a vaccination that plaintiff sees defendant preparing for plaintiff conveys afferent consenting to the injection. Next one. Defense of the defense of others. A person's right to use reasonable force to defend another person against attack. Defendant sees plaintiff who's slowly crossing in the street. Defendant believes that plaintiff is about to be struck by an SUV. So he pushed plaintiff out of the way, causing her to fail and break her hips. If the defendant was reasonable in his belief that plaintiff was likely to hit the SUV, if she was not pushed out of the way and reasonable in the amount of force he used, he will be able to use defense of another